I think Mr. Stiller's on some of the other cases, but sorry, Mr. Stiller, handling much stuff. Good afternoon, or good morning, Assistant Public Defender Lauren Perning on behalf of Mr. Dunlap on the cases ending in 0353 and 0354.
This is where it all begins, and it's immediately a bit of a mess. Judge Simpson asks a straightforward question, what are we doing? And suddenly both sides start scrambling to piece together a last-minute resolution. You can literally feel the hesitation in their voices. The defense throws out a Hail Mary, pleading all three criminal cases down to a civil infraction, double parking. That's right, from felonies to parking violations. This is where legal negotiations become pure theater. This moment reveals the strange flexibility of courtroom justice, how strategy and timing can drastically shift the course of a case. But here's the kicker. The prosecutor isn't even officially on this case until Friday. So who's actually authorized to make the deal?
Good morning, Your Honor. The Plea is Honorable Court. Brandon Bird on behalf of Vincent Dunlap on the case ending in 0589.
All right. And what are we doing?
Oh, Your Honor, respectfully, got to speak with brother prosecutor and counsel over here, and we would like to plead all three cases to the civil infraction of a double parking.
That's correct, Your Honor.
Yeah, there's a state case that wasn't part of any resolution I was involved in negotiating.
I'm not a prosecutor. Detail fraud case. I'm only a prosecutor for review.
That's why I thought I spoke with you earlier. Awkward. Your Honor, respectfully, can we adjourn this matter to see how his other felonies play out? I know his preliminary exam got pushed back. Last time we adjourned it to see what was going to happen.
Do you want to adjourn yours out?
Please, Your Honor.
I have July 16th or August 6th, which is the preference if you're trying to time it up with an exam date.
July 16th, Your Honor.
July 6th. This being case 589, I'll adjourn that matter to July 16th, 2025, 9 a.m. Bond on that matter will continue.
Okay, let's break this down. Judge Simpson has now granted an adjournment to July 16th and extended bond for Mr. Dunlap. This move is more than just pushing paperwork down the line. It's a strategic pause. The defense wants to see how Dunlap's other felony cases play out before resolving this one. This is called waiting on the preliminary exam, and it's like playing poker with half the cards still face down. If the felonies fall apart, Dunlap might walk away with just a slap on the wrist. But if they hold, this case suddenly has more weight. Judge Simpson's calm demeanor might seem routine, but he's juggling multiple timelines, legal outcomes, and personalities, all without losing control. That's courtroom finesse. Should judges allow these delays to see how other charges unfold, or does it give defendants too much wiggle room?
My cases are the cases with Mr. Stiller, Your Honor, so I would, we are going to...
Double parking on both.
Correct.
And double parking in each case, Your Honor. I'm going to move that count to in each case, double parking. If you accept that admission deed in each case, and it's just the original charge in each case.
That's a correct statement.
That is, Your Honor. Thank you.
Mr. Dunlap?
Yes.
In the case ending in 353, do you admit responsibility to the fact that on April 2nd, 2021, Pittsfield Township, that you double parked a motor vehicle?
Yes.
On the case ending in 354, on the date of April 2nd, 2021, do you admit responsibility to the fact that you double parked a motor vehicle in Pittsfield Township?
Yes.
Court will accept those admissions in each case. Count two. Count one is dismissed. In each case, fines and costs are $180, so that's total amount of $360. Has to be paid 60 days. I'll make it 90 days after release.
We just witnessed a legal magic trick. 3 cases, all bundled up and resolved with one tidy bow. Double parking, $360 in fines, 90 days to pay, no jail, no probation, no lasting record if paid on time. What's fascinating is the contrast between the charge's original weight and how it all wrapped up. The judge accepted the plea, dismissed the primary counts, and issued a penalty that sounds more like a parking ticket. But make no mistake, this is a calculated move. Why 90 days after release? Because Judge Simpson knows Dunlap is likely incarcerated on other charges. The court isn't trying to trap him, it's giving him room to comply. Legal insight. This tactic is called structured leniency. Courts sometimes reduce friction for defendants with ongoing cases. Knowing compliance later is better than default now.
Thank you, Your Honor.
Thank you.
All right.
Court does call the case of the people versus Juliet von Oceanbear Martinez. This is Mr. Siller's case. All right. Ma'am, can you state your name, please?
Devin Julia Martinez.
All right. Pardon? Yes. Mr. Martinez, this is an arraignment on a misdemeanor complaint that alleges that on or about May 18th, 2025, at the location of Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you were in possession of drug paraphernalia. Do you understand the nature of that charge, ma'am?
Yes.
That's a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court costs, and any substance abuse counseling the court deems necessary. You understand that?
Correct.
All right. And my first question to you is, do you want to be represented by an attorney?
Here comes Juliet Oceanbear Martinez. And if you thought Dunlap's case was confusing, this one is straight up chaotic. Before the judge can even ask about an attorney, Martinez is already unsure whether she needs one. What's striking is how much Judge Simpson has to babysit this moment. He's asking a foundational question. Do you want legal representation? And the defendant is wobbling between yes, no, and can I just handle this myself? It's a legal red flag wrapped in hesitation. This is also where we see the emotional layer come in. Martinez isn't trying to be difficult. She's clearly overwhelmed. The judge's tone softens slightly, signaling empathy, but he's also drawing a clear boundary. If you were in her shoes, facing a drug paraphernalia charge, would you go it alone or lawyer up fast?
It isn't
Pardon?
necessary. It isn't
Is it
necessary.
necessary?
It isn't necessary.
Well, it might be.
I said it isn't necessary, so could I just speak for myself?
Okay, what do you want to do on the case?
Just let me think.
Hey, Ms. Martinez,
Yeah.
are you still, you had other cases a while back. Are you still on probation on those cases?
No.
Okay, so you're not before the court on any other things?
I am. But none of them are drug related. And they're about to be finished.
Well, maybe.
That well maybe might sound casual, but it's loaded. Judge Simpson is gently trying to navigate the fog of Martinez's response. She admits she has other cases but doesn't want to elaborate. He presses not out of nosiness, but because this new charge could trigger major consequences elsewhere. And then comes the most jaw-dropping line. Is there any way to forget about this somehow? That's not how court works. This isn't a bartering session or a high school detention. Martinez's request, while emotionally raw, reveals how disconnected some defendants are from the formal legal process. And it's heartbreaking too. She's not trying to be defiant, she's trying to find the off switch. Legal insight. When a defendant is unclear about the ripple effects of their charges, the court has to walk a tightrope, protect their rights while maintaining the process. Judge Simpson handles that line with grace here.
What other courts are you before, Ms. Martinez?
Is it necessary to expound upon this?
Pardon?
Is this relevant?
Well, it could be, because you could be facing additional sanctions depending on those cases, depending on what happens in this case.
Well, is there any way to live this down? Have it
To do what?
have it go is there any way to forget about this somehow? Is there anything that I can do community service or something that could do instead of
Ms. Martinez, you don't have that's why I think you would need an attorney. I mean, you can proceed on your own if that's what you want to do. But quite frankly, me knowing a little bit about your history, I don't know that would be a wise call on your part.
So, like what, like, I suppose.
Ms. Martinez, just answer me this. Are you represented by the public defender's office on your other matters?
Yes.
Okay, don't you think it might be wise if they help advise you on this matter and also help you with those other matters? Doesn't that make sense to you?
In a way.
In a way. Okay, in a good way?
This moment is pure gold. Judge Simpson is clearly trying to make sense of Martinez's logic or lack thereof. She says going with the lawyer is a good idea in a way. The judge echoes back in a good way, like he's trying to ground her back into reality. What we're witnessing here is a classic case of judicial patience under pressure. He's dealing with someone teetering between full cooperation and complete mental fatigue. Martinez is bouncing between wanting a lawyer, denying guilt, admitting guilt, and asking to forget the charge entirely, all in one breath. This is where a courtroom stops being about law and starts becoming human drama. It's not just about guilt or innocence, it's about decision-making under emotional fog. Think about this. Should courts assign mental health advocates more often in cases like this, especially when confusion and anxiety are visibly impairing the defendant's ability to respond?
In a way that is like, I can, have this, be adjourned with a bond. Can I know what the bond is?
Ms. Martinez, I don't even have a plea from you at this point.
Oh, please, I'm guilty.
No, I didn't mean that.
Oh.
So,
I'm not protesting to the allegations. I would like to
well,
just,
but hold on. I don't want you saying anything about the offense.
well, I do. I see no way around it. It's plain and clear and simple.
Well, I know that, and that's why people get attorneys, because sometimes they don't see any way around it.
But it's clear. It's plain. Like,
Well, I don't know that, Ms. Martinez.
yeah, I guess I'll go with the lawyer. Sure.
You will? Good. Okay, public defender case.
Assistant Public Defender Natalie Pate on behalf of Ms. Martinez. Your Honor, we would waive any further reading. My client stands mute and ask that a not guilty plea be entered. I would ask, Your Honor, for an adjourned pre-trial date. However, a more lengthier adjournment. The public defender does represent Ms. Martinez on her other matters. She actually has been referred to the Forensic Center and does have an appointment today with them. So I would ask for a lengthier adjournment to that end, Your Honor.
You should have led with that.
That's right.
All right.
The appointment is today?
When she has the appointment today?
It's scheduled for today per the letter from the center.
Got it. Do you know when the hearing date is set on the other matter?
Her latest court date in circuit court is July 28th, and her bond is denied on that case. So I believe it's the 28th.
Okay. So what I will do is I'll adjourn this matter out to August 6th, 2025, 9 a.m. I'll set the defendant's bond so that she's getting credit because she's being held on that other case. I'll set her bond at a $5,000, 10% bond on this case.
Judge Simpson just hit the brakes on the whole situation and laid out a clear path forward. Martinez's bond is set at $5,000 with 10%, which means she needs $500 to walk, but there's more going on beneath the surface. He's not setting this bond just to slap on a number. He's aligning it with the reality that she's already incarcerated on a different charge, and her public defender is juggling multiple matters. He even structures the bond to ensure she gets time credit, a small but significant gesture in courtroom fairness. This is a moment of judicial balance, not punishing unnecessarily, but not letting the case flow either. Simpson makes it clear, this will proceed like any other, with proper legal support and structure in place. Legal breakdown. A 10% bond shows the court is not averse to release, but the underlying felony still keeps the defendant in custody. It's leverage and leniency in one stroke.
Order standard conditions, including no assaultive behavior, no alcohol, recreational marijuana, or any illegal drugs. All right, thank you.
Thank you, Your Honor. Thank you, Ms.
This-
Martinez. Well,
Miss,
well, I'll
ma'am,
be down.
it says on the forensic center is coming to see me today.
It's scheduled for today, but I'm not sure if maybe I don't have the most updated information. So there's a chance it might be rescheduled, but from what I can see, it looks like it was scheduled for today. But either way, we'll be in touch, Ms. Martinez. But you're all set for court here today.
What is your name?
We're all set for court here today, Ms. Martinez, but I'll be down to see you before August.
Okay, but what is your name?
Oh, sorry, Natalie. I did not hear. I apologize, Natalie.
Natalie who? Natalie who?
Natalie Pate.
Pete. Thank you.
All right, thank you.
Thank you, Ms. Martinez.
Court does call the case, People versus Jacqueline Murray.
Good morning, Your Honor.
Morning.
Timothy Dinan, P49499. I'm here on behalf of Mr. Howard, who now appears on my right.
Your name, sir?
Adam Swords.
All right, what are we doing?
Oh, Your Honor, this morning I spoke with counsel, and my client's asking to tender a plea of no contest to the charge. I understand that people do not have an objection to that and have forwarded to the court a copy of the police report.
That's correct, Your Honor.
This is the one that was sent to me. Okay. I have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
Adam Swords.
Sir, it is this court's understanding that you're going to plead no contest to the charge of operating motor vehicle without security. That's a misdemeanor punishable by up to 1 year incarceration, not less than a $200 nor more than $500 fine plus court costs. You understand that, sir?
Yes, Your Honor.
All right. And understanding that you still wish to plead no contest?
Yes, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right, two things about it I have to make sure that you understand, and that means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
I understand, Your Honor.
Still want to plead, and the basis for no contest plea, counsel?
Civil litigation, Your Honor.
Liability. All right. Sir, to that charge, how do you plead?
No contest, Your Honor.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
This part is all business. Adam Swords is entering a no contest plea, and Judge Simpson is making sure every single legal checkbox is ticked. No trial, no appeal, no wiggle room. What makes this moment so sharp is how clearly the judge explains the implications. Pleading no contest is legally equivalent to pleading guilty, but without admitting the offense. It's like saying, I'm not fighting this, but I'm not fully confessing either. And that's often used when there's civil litigation in the background. Swords is composed and respectful, but you can tell from the careful pacing that this moment holds weight. The judge walks him through every right he's giving up. Right to trial, appeal, protection against self-incrimination, and confirms again and again that he understands. Note for viewers, this is not just legalese, this is legal armor removal. Once a plea like this is locked in, there's no turning back.
Yes, Your Honor.
Has he signed an advice right?
I believe we tendered it last time, Your Honor, to the court. If need be, I have gone over his rights with him, though.
Yes. All right. We could, yes, have him.
Happy to do so, Judge. Let's flip it over, buddy. It's July 2. Thank you. Your Honor, he's executed that.
All right. Do you have any questions regarding any of those rights on that form?
Oh, Your Honor.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of trial. Indicated by pleading guilty, you'll be giving up those rights as well as all the rights on the form.
I understand, Your Honor.
You understand you're giving up your right to appeal of right?
I understand, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's in state? Well, promise you anything to get you to plead guilty?
Just what we agreed to, Your Honor.
The no contest plea, Your Honor.
Gotcha. Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
The court has received and reviewed Pittsfield Township Department of Public Safety report for their case number 253831. Any objection to the court having reviewed that report?
None, Your Honor.
No, Your Honor.
All right. Is counsel aware of any inducements, promises, threats that have led to this plea, other than what's been stated on the record?
No, Your Honor.
No, Your Honor.
All right. And the court does not believe that the admonishment regarding misconduct will be necessary because I'm going to immediately sentence him. Counsel, have I complied with the court rule? Would it be proper to accept this defendant?
It would be proper, Your Honor.
Yes, sir.
Court will accept the defendant's plea of no contest to this charge. Anything, counsel, you or your client want to say before I impose sentence?
Judge, my client has a clean criminal record. He's had some financial problems as of recent. He is self-employed. He's also had a lengthy separation from his family. His wife left the country essentially with his children, and it's been a challenge. All the vehicles he drives now are properly insured and properly licensed. And I think my client's earned a valuable, if not very expensive lesson.
Now this is powerful. The attorney lays it all out. Adam Swords isn't a career criminal. He's a self-employed man going through a rough financial stretch, separated from his kids, trying to rebuild. It's raw, it's real, and it's persuasive. This is one of the rare times a defense attorney paints a sympathetic picture without asking for pity. Instead, it's framed as growth. Every legal observer knows judges respond better to accountability, blunt insight than just a sob story. And that's exactly what this defense delivers. Even Swords himself says, "My attorney said it best." That's a sign of alignment between client and counsel, which always lands better with a judge. Legal insight. When mitigating factors are humanized, not dramatized, it shifts the emotional compass in the courtroom. Judges, after all, are people too. Would this backstory shift your opinion on the case? Drop your thoughts below.
Sir, anything you want to tell me?
I believe my attorney represented it very well. But thank you, Your Honor.
Fines and costs of $300, a loader 365 days in jail that is suspended. When do you think you can get that paid, sir?
We each pay $300, buddy. 2 weeks.
Yeah, that's okay.
Your Honor, if you can just give us 14 days, that'll be plenty of time.
I know, stuff happens. So August 1st.
Thank you, Judge.
You're welcome.
Thank you.
Have a good day.
Good seeing you.
Thank you.
Oh, thanks for your help today.
Is that it, sir? Block?
Thank you, Your Honor.
All right, that's it for that block. I'll take a brief recess. We'll come back. We'll start our time.
Thank you, Your Honor, for that conference.
The record should reflect we've had a brief bench conference. So, the plea form that the court indicates that the defendant would be pleading guilty to the charge of operating while impaired. The 93-day offense. Upon a successful plea, count 1 would be dismissed. That is the court's full understanding of the agreement. Is that correct, Counsel?
Yes, Your Honor.
Yes, it is, Judge. Thank
All right. Very good. May I have the defendant sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Lisa Keebler.
Keebler, this court's understanding you're going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor, punishable by up to 93 days in jail, a $500 or $300 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
I do.
All right. And understanding all of that, you still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind. All right. You signed an advice of rights form, is that correct?
Yes.
Yeah.
Any question regarding any of those rights?
No.
All right. Look at paragraph 5. There's a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will?
Yes.
All right. And because you believe that you are indeed guilty?
Yes.
All right. On June 29, 2024, at the location of 8265 Dexter Chelsea Road in Scioto Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
I had.
And that was evidenced by an intoxilizer result or blood test result?
It's a blood test result, Your Honor.
All right. A blood test result.
Yes.
Counsel, it's the court's understanding that the parties are stipulating to a 0.194
That's correct.
blood alcohol.
Yes, Your Honor.
All right. And Ms. Keebler, you don't have any reason to dispute that
No.
result. All right. Why did the police pull you over?
I hit a mailbox.
All right. So there was an accident of some type. All right. And the police arrived.
Yes,
And that's how the blood test was taken. Ultimately, you were arrested. That's how the blood test was taken.
correct.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes,
All right. Prior to accepting your plea, I do have to advise you that if you commit misconduct as defined under the court rule from the time I accept your plea to the time of sentencing, that any agreement regarding sentencing or any evaluation, the court would not be bound by. You understand that, ma'am?
yes,
You also could, if you commit that misconduct, could not use that or would not be permitted to withdraw your plea. You understand that?
yes.
Counsel, do you know of any other promises, threats, or inducements which have led to this plea?
No, Your Honor.
No, Judge.
And have I complied with the court rule, and would it be proper to accept this defendant?
Yes, Your Honor.
Yes, it would.
The court will accept the defendant's plea of guilty to count 2. Should put that in a different spot. Count 1 is dismissed. Defendant is referred to probation. Excuse me, I'm sorry. She's referred to bond sports for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
July 30th, 2025 at 12 p.m.
July 30th, 2025, 12 noon.
Thank you, Judge.
Thank you.
Thank you.
Okay.
And that wraps up a courtroom docket that gave us everything from last-minute plea deals to emotional unraveling and legal redemption arcs. Let's break it down. Vincent Dunlap walked away from 3 charges with a civil infraction and $360 in fines. Juliet Martinez teetered on the edge of representing herself before finally accepting a public defender with bond set as she undergoes mental evaluation. Adam Swords took full accountability with a no-contest plea, showing how personal hardships can intersect with legal responsibility. And Lisa Keebler, a DUI charge with an admission of guilt and a blood test to seal it. Judge Simpson moved through each case with clarity, restraint, and authority, balancing the courtroom's procedural needs with the unpredictable reality of human behavior. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Who surprised you most in this episode? Drop your take in the comments.